Okay, so picture this for a second. You've poured everything, right? Resources, innovation,
Years, maybe.
yeah, years into perfecting something. You get the patent, that official thing that says, hey, this is mine.
Your unique idea legally protected.
Exactly. And
Yep.
then, bam, you see someone else, a competitor, selling something that looks, well, suspiciously like they just copied your work.
It took a shortcut using your tech.
Right. It's
Mhm.
more than just frustrating. It's the start of a patent fight.
Mm.
Today, we're doing a deep dive into exactly that kind of situation. It's a specific, pretty long-running case from India. Strix Limited versus Maharaja Appliances Limited.
Yeah, and we've got the court documents right here, the whole story.
Yeah.
What both sides argued, the evidence or lack thereof.
And the judge's final word.
Exactly. The detailed reasoning.
So our mission today is to really peel back the layers on this. It's a complex legal battle. We want to understand what Strix said was infringed, what Maharaja's defense was,
Why the court ruled the way it did after all that time.
and maybe most importantly, what does this all mean? What are the takeaways for anyone dealing with intellectual property?
Definitely. And this case, it touches on quite a bit. I mean, from the technical side of electric kettles
Right, safety controls.
to the real nitty-gritty of Indian patent law, and even how courts figure out damages when one side isn't exactly cooperating.
Okay, let's get started. Let's unpack it.
Let's do it.
All right, first up, the players. The plaintiff is Strix Limited. They're incorporated in the Isle of Man.
Right, used to be Castletown Thermostats, I think.
That's the one. They're basically global leaders in kettle controls, temperature controls for water boiling things. They sell these components everywhere.
And the defendant facing the lawsuit is Maharaja Appliances Limited, an Indian company.
The invention at the center of it all is Strix's Indian patent, a yen 1925-195. The title is Liquid Heating Vessels.
Okay, so this patent, it was granted November 11, 2005, valid until June 8, 2015. But the key date here is the priority date.
Ah, yes, always important.
June 9th, 1994. That comes from an earlier UK application. And that date becomes crucial when we talk about what counts as prior art.
Makes sense. So what did this patent actually cover? What's the invention?
Well, it's for a liquid heating vessel, think electric kettle, basically with an electric heating element, obviously,
Standard stuff so far.
but with a specific kind of thermally sensitive overheat control. The core idea, the claim, involves having at least two thermally responsive sensors.
2 sensors. And where the go-to?
Placement matters. They need to be in good thermal contact with the container base, or maybe the element itself, and crucially, at spaced-apart locations.
Okay, 2 sensors, specific locations. What makes them special?
Here's the clever bit, the technical distinction. They're designed to operate individually if the element overheats, like if the kettle boils dry or someone switches it on empty.
Ah, the safety cutout.
Exactly, they shut it down. But, and this is key, they don't trip during normal boiling. The critical difference the patent points out is they sense the temperature of the heating element itself.
Not the water temperature. Or the outside.
No, not the liquid temp, not the ambient temp. It's about the element getting too hot, which indicates a dangerous condition like boiling dry.
Interesting distinction, and Strix said they were using this.
Yeah, they claimed they'd been using this invention since 2002. And the specific product line, the U10 series controls, they'd been selling internationally since 1996. So they were actively commercializing it.
Okay, so Strix has this patent, they're using it. How does Maharaja Appliances get involved?
Well, here's a bit of a twist. Turns out Maharaja Appliances actually bought these patented controls directly from Strix for a while.
Really? When was this?
According to the court docs, this was back in 2005-2006.
So they were customers first. Then what happened?
Then in 2007, Maharaja stopped buying from Strix. They started importing similar-looking controls from a company in China instead.
Ah, okay. And Strix noticed this.
They did. And they looked into it. They found a specific kettle model. Maharaja was selling the Maharaja White Line Model No, EK172, and concluded it was using a control system that infringed their patent.
So Strix wasn't happy. What did they do?
The usual first step. They sent a cease and desist letter, September 27, 2007.
Basically, stop selling that kettle.
Right. Followed it up with a reminder in November.
And Maharaja's response?
They replied through their lawyer a few days later, November 17th, and they basically said, nope, we deny everything.
Okay, so negotiation didn't work. Court time.
Looks like it. Strix filed the suit, CSQMM 403-2018. They wanted the court to order a few things. Stop Maharaja permanently.
An injunction.
Yep. hand over the infringing kettles,
Delivery up,
make them show their sales figures,
rendition of accounts.
and pay damages for the infringement. The court issued summons on June 2, 2008, so the legal gear started grinding.
But Maharaja didn't just sit back and defend.
No, they went on the attack. They filed a written statement defending the infringement claim, but also a counterclaim,
What was the counterclaim about?
challenging the patent itself. They asked the court to revoke Strix's patent entirely, arguing it wasn't valid in the first place.
A common tactic, right? If the patent's invalid, you can't infringe it.
Precisely.
Did anything happen early on before the main trial?
Yes, Strix had an early success. They got an interim injunction on September 10th, 2009.
So Maharaja had to temporarily stop selling the kettle.
That's right. At that stage, the judge felt Strix had a good initial case, a prima facie case. The judge also mentioned that Maharaja's challenge to the patent's validity didn't seem very strong at that point.
And didn't the court say something about Maharaja buying the controls earlier?
Yeah, interestingly, the court noted that Maharaja's own past purchases actually supported Strix's claim that the patent was being commercially used or worked in India.
But these were just initial findings.
Exactly. The court was very clear. These were temporary observations for the injunction only. The final decision would depend entirely on the full trial evidence.
Got it. So the legal questions for the trial, the issues, were set out.
Yep, framed on October 20, 2009. Initially, the money part was just damages, but later they amended it specifically to rendition of accounts.
Trying to get those sales figures.
Right, aiming to figure out Maharaja's profits from selling the accused kettles.
Okay, let's dig into Maharaja's defense. What were their main arguments for why they shouldn't be liable and why Strix's patent should be revoked?
They had several lines of argument. First, they attacked the patent's validity head-on.
How so?
They claimed it wasn't a real invention under the Indian Patents Act, Section 2J. They basically said the technology already existed, it was in the public domain. They cited Section 64, which lists grounds for revoking a patent.
Did they mention specific reasons why it wasn't inventive?
Yeah, they argued it lacked an inventive step. Said the control was just a normal feature, a simple rearrangement of stuff that was already known from prior art.
And did they point to specific prior art?
They did. They named 3 documents: a European patent, EP0469758, a U.S. patent, 6818866, and a PCT application, W01999-29140. They specifically claimed that European patent taught the same thing.
Okay, so invalidity was a big part. What else?
They also argued they were just a bona fide importer. They said they bought the controls from a Chinese company who they claimed held its own patent on the product.
So the idea was we bought it legally from someone else who has rights, maybe hinting at Section 107AB about authorized imports?
Possibly, yeah. That seemed to be the implication, that their import wasn't infringement because the source was supposedly legitimate.
What else did they argue?
They accused Strix of suppression of facts. Claimed Strix hadn't told the court about allegedly supplying defective kettles to Maharaja back in 2005-2006.
Trying to paint Strix as not having clean hands.
Seems like it. Implying Strix wasn't being entirely upfront, which could hurt their case for relief.
And they challenged the working of the patent.
Yes. They argued Strix hadn't actually manufactured or sold the kettles in India since 2002, trying to poke holes in Strix's claim of commercial exploitation here.
Any procedural arguments?
A couple. They questioned if the lawsuit was properly filed, specifically whether the person signing for Strix had the authority.
Standard legal check.
And they emphasized they were just traders, importing finished kettles, not manufacturing the heating parts themselves, trying to distance themselves from the core technology, perhaps.
Okay, so that's Maharaja's side. How did Strix push back against all this?
Well, Strix countered each point pretty methodically.
First things first, I assume they proved they actually owned the patent.
Absolutely. Provided the certified grant documents, proof of paying the renewal fees. Plain and simple. It was their registered, valid patent.
And on infringement.
Their argument was direct. Maharaja's kettle, model EK172, used a control system identical to what their patent claimed. They presented a feature-by-feature comparison, mapping Maharaja's product directly onto their patent claims.
Showing the overlap.
Exactly. And they defended the patent's validity robustly. It was granted. It hadn't been revoked.
What about the prior art Maharaja cited?
Strix tackled that head-on. For the U.S. patent and the PCT application, they pointed out a critical flaw. Their priority dates were later than Strix's own 1994 priority date.
So they couldn't be prior art.
Correct. Can't anticipate something that came later. As for the European patent, EP0469758, which did have an earlier priority date.
The one Maharaja claimed taught the same thing.
Yes. Strix argued it was technically different. They went back to that core distinction. EP04699758 sensed liquid or ambient temperature for boilover prevention.
Right.
Strix's patent sensed the heating element temperature for dry switch protection. They argued this was a completely different mechanism, proving novelty and an inventive step over that prior art.
Makes sense. And the working in India argument.
Strix turned Maharaja's own words against them. They pointed to Maharaja's admission in their court filings that they had bought Strix controls in 2005-2006.
Using their own statement as proof.
Exactly. Proof that the patented technology was being commercially exploited in India.
What about the other defenses? The bona fide importer claim?
Strix called that out for having zero evidence. Maharaja never named the Chinese supplier, never produced any Chinese patent proof.
So just an assertion with nothing behind it.
Pretty much. Strix even noted they'd successfully enforced their own corresponding patent in China against others, casting doubt on Maharaja's claim.
And the suppression of facts allegation about defective kettles?
Strix dismissed those as mere bald allegations. Again, no proof offered by Maharaja, and Strix pointed out their patent details were public record anyway.
And the technicality about who signed the lawsuit papers?
Strix cleared that up easily by providing the official board resolution authorizing their representative, Mr. Hewins.
Okay, so arguments laid out, it goes to trial. Strix presents its evidence. What happens with Maharaja?
This is where things took a decisive turn. Maharaja did file an affidavit from a witness, Mr. Sujit Yadav, but that witness never actually appeared in court for cross-examination by Strix's lawyers.
Uh-oh. That's usually not good.
Not at all.
Yeah.
There were also issues with their witness list early on. Then there were delays. The court imposed costs on Maharaja. Later, another person, a Mr. Shashi Shekhar, showed up, maybe as a potential witness.
But
Maharaja apparently never took the proper steps to formally substitute him or get his evidence on record correctly.
so a pattern of procedural issues. Or maybe intentional delay.
The court seemed to think the latter. On May 21st, 2014, the Joint Registrar, who handles procedural matters, issued an order closing Maharaja's evidence.
Meaning they couldn't present their side anymore?
Essentially, yes.
Yeah.
The registrar found their actions pointed towards an intention to just delay the proceedings.
Wow, what happened then?
It got worse for Maharaja. Their lawyer asked to be discharged from the case. And since Maharaja wasn't participating or represented anymore,
They were declared.
they were proceeded against ex parte.
Meaning the trial continued without their active participation.
Exactly. They weren't there to present a defense, challenge Strix's evidence, or argue their case further. A huge disadvantage.
Okay, so the case eventually gets decided. Justice Pratibha M. Singh is the judge. How did she break it down?
Very systematically. She went through each of the issues framed for the trial and decided them based on the evidence or the significant lack of evidence from Maharaja.
Issue 1. Is Strix the patent holder?
Decided for Strix. Easy one proven by the certified documents.
Issues 5 and 6. Patent validity and Maharaja's counterclaim to revoke it.
Decided against Maharaja for Strix.
Why?
Primarily because Maharaja led no evidence at trial to prove their claims of invalidity or to support the prior art documents they mentioned. The judge stated their pleadings were not even been proved.
Just making the claim wasn't enough.
Not even close. You have to
Yep.
back it up in court. Though the judge did analyze the prior art anyway, just to be thorough.
And what was the finding on the prior art?
Same as Strix argued. The U.S. patent and PCT application were rejected because their priority dates were after Strix's.
Not prior art.
Right. The European patent EP04699758 was prior art, but the judge found it distinguishable. She agreed with Strix it sensed liquid and ambient temp, while Strix's patent sensed the element temp. A completely different mechanism, she called it. Didn't destroy novelty or inventive step.
And the working in India point.
Also rejected. The judge pointed straight back to Maharaja's own admission of buying controls in 2005-2006 as proof Strix was commercially exploiting the patent.
Okay, issue 2. Infringement. Did Maharaja's kettle infringe Strix's patent?
Decided for Strix.
Based on
The claim comparison. The judge found the features of Maharaja's kettle mapped fully onto Strix's patent claims. She applied standard infringement principles looking beyond literal wording, using purposive construction, considering the pith and marrow or essence of the invention.
And Maharaja's absence hurt them here too.
Definitely. No counter-arguments, no evidence to dispute Strix's infringement case during the critical trial phase.
Issues 3 and 4. The bona fide importer and suppression of facts defenses.
Both decided against Maharaja. Lack of evidence was the killer. No proof of the Chinese supplier, no proof of a Chinese patent, no proof of defective kettles or suppression. Just Bald allegations, as the court put it.
And issue 7 was the suit properly filed.
Decided for Strix. Proven by the board resolution.
So Strix wins on all the substantive issues. What about the remedies they asked for? The injunction, the delivery up, the money?
Well, this is where the timeline becomes really important. The permanent injunction and delivery up, those were not granted.
Why not if they won on infringement?
Because by the time the judgment came out in 2023, the patent itself, in 1925-11-195, had already expired back in June 2015.
Ah, so you can't stop someone from infringing an expired patent.
Exactly. Those requests were infructuous, legally moot.
But what about the money? The past infringement?
That's where Strix did get a remedy. The court awarded monetary compensation and costs.
Why compensation if they couldn't do a precise rendition of accounts?
Because infringement had happened while the patent was valid and after Strix had warned Maharaja. And crucially, because Maharaja's deliberate non-participation made a proper accounting impossible.
So Maharaja couldn't benefit from hiding their sales figures.
That was the court's reasoning. It would be unfair. So the DJAP made a broad assessment of the compensation due.
Based on what?
Based on the evidence, Strix could provide estimates, Maharaja's business info, plus guidelines from IP rules and case law on how to handle damages when accounts aren't available.
And the final amount?
It was significant. Damages of 50 lakh rupees.
Wow, okay.
And actual costs awarded were around 31.4 lakh rupees.
So total?
Total decreed amount, about 81.4 lakh rupees. Roughly just under 100,000 US dollars in damages and costs combined, maybe a bit more depending on exchange rate.
Plus interest if they didn't pay quickly.
Yeah, 7% simple interest if not paid within 3 months of the judgment date, October 20, 2023.
This seems like a pretty important judgment then, especially coming from the Delhi High Court.
Absolutely. It carries significant weight, sets precedent there, and is persuasive elsewhere in India.
What are the key legal takeaways or precedents set here?
Several things. It clarifies interpretation of the Patents Act, what's an invention, patent rights, grounds for revocation, the limits of that bona fide importer defense.
Reinforces how infringement is analyzed.
Yes, confirms the purposive construction and doctrine of equivalence approach, looking at the substance, not just the words.
And crucially, the damages aspect.
Hugely important. It explicitly rejects punitive damages in these kinds of civil patent cases, following higher court rulings.
But confirms compensatory damages.
Yes, and shows how courts can estimate those damages using a broad assessment when the infringer doesn't cooperate with providing accounts, setting relevant case law for that.
And awarding actual legal costs, too.
Right, confirming the court's power to do that in commercial cases, based on Supreme Court guidance. Not just nominal costs, but what the winner actually spent.
It also seems like a massive warning about not participating in your own defense.
Definitely. Maharaja's conduct, the non-appearance, the delays, going ex parte, directly led to adverse findings on validity and made the damages assessment possible in this way, a clear consequence.
And just that minor correction order later.
Yeah, court agendum order just fixed a case citation, didn't change the substance at all.
And this was Justice Singh's decision alone.
Seems so. The judgment is authored by her as a single judge. No mention of a bench or dissent.
So, wrapping up, this case started with, well, cattle control system. Seems simple.
But it spun out into this decade-plus legal saga. Covered fundamental patent law principles, burden of proof.
And how courts calculate financial harm when faced with non-cooperation.
Yeah, it really highlights how critical it is for a defendant to actually show up and prove their case if they hope to win, especially on validity challenges. Their absence here was just devastating for their defense.
And it gives a clear signal from the courts on damages in IT cases in India. No to punitive, but yes to potentially substantial compensatory damages and actual costs.
Especially if the infringer tries to obstruct the process of figuring out profits.
It also shows how patent life cycles interact with litigation. The patent expired, so no injunction.
But the financial reckoning for past infringement.
Yeah.
Still very much on the table. Retrospective justice, in a way.
So for companies, what's the message? Ignoring patents or hoping a flimsy defense works without proof.
It's a really risky gamble. The cost can be very high, even years later.
And for you, the listener, it's just a reminder that behind everyday products,
there can be layers of complex IP, technical details fought over tooth and nail, and significant legal battles.
Okay, here's something to chew on. If a patent expires during a long lawsuit, you can't stop the infringement going forward, but you can still get paid for the past damage.
Right.
How does that potential for a big payout, even on an expired patent, change the game for deciding whether to litigate or settle? It seems like a strong reason for patent holders to see it through, doesn't it?
That's a really interesting question. Does the potential for significant damages, even after expiry, make fighting a losing battle even less appealing for an alleged infringer? Or does it incentivize the patent holder to push harder, knowing there's still a financial remedy available regardless of the patent's current status?
So the big takeaway, navigating IP isn't just about the tech. It's about law, timelines, strategy, and participating effectively if a dispute arises. Definitely something to ponder.
Indeed. Maybe over your next cup of tea.